Thank you, Mr. Chairman. I appreciate this committee allowing me to testify, and I testify on this subject all over the country, and I want to just commend you. You guys have showed extraordinary patience today in listening to all this, and I just really appreciate it. I am going to deal solely with the question of whether it can run away. Let me give you a little background. I'm a constitutional lawyer. I've argued successfully twice in the Supreme Court of the United States on constitutional issues. I have also argued successfully constitutional issue in Supreme Judicial Court of Massachusetts, even though I'm from Virginia. And I have litigated a case under Article 5 concerning the process of the ratification of the Equal Rights Amendment. The assertion that was made by several people earlier, more in relationship to the campaign finance issue, but the principles are the same, with whether or not a convention would be limited to its subject. The claim was made repeatedly that there is no precedent. Well, in a very technical, precise sense, that's true. Since we've never had a convention, there could never be a legal challenge to such a convention. But that doesn't mean, just because there's no specific precedent, doesn't mean that there's no general precedent. There is general precedent, and it's unassailable. And that all principally arises from the Equal Rights Amendment litigation. In that case, in that situation, Congress proposed the Equal Rights Amendment with a 7-year deadline. They purported to change the deadline and add 3.5 years on that. I was in that litigation representing legislators from the state of Washington. And then subsequently, in the last half dozen years or so, 3 states have claimed to ratify it despite the 7-year deadline, despite the expiration of the second deadline, and that's been litigated as well repeatedly. And every single court that has dealt with this issue has said that you can't change the rules in the middle of the stream. If you say you're coming together for 7 years, it's 7 years. Republican appointed judges, Democratic appointed judges, every single judge has said you can't change the rules in the middle of the stream. If you call a convention for a specific purpose, you can't change the rules in the middle of the stream and go off for a different purpose. The claim that this was done for the Constitutional Convention originally is a historical fallacy. I published an article in the Harvard Journal of Law and Public Policy that refutes this. It's called Defying Conventional Wisdom. If you Google my last name, Farris, F-A-R-R-I-S, and Defying Conventional Wisdom, the article will come up readily on the internet for free. You can see that the original Constitutional Convention was not a runaway. The delegates obeyed their instructions that they got from their states. So the reason we have this convention is because Washington won't change itself. I don't care if the issue is term limits or balanced budget or campaign finance. You will be wishing and hoping forever if you expect Washington to fix any of these things, including campaign finance. The only way it's going to happen is to use the safety valves the framers gave us, and that is call a convention of states, and 38 states must ratify. The idea that someone said that they could change the ratification rule and not have 38 ratifications is not a serious statement. No lawyer would take that seriously. That's just simply fantasy land. I urge you to pass this 3541, and I thank you for your extraordinary patience.